Update August 20th, 4:02 p.m. Eastern Time. Hours after this announcement, Lyft and Uber were granted an emergency stay by the California Court of Appeals, averting their planned shutdown. The companies will now have until October to convince the court to toss out an order that they classify drivers as employees. In a statement, Lyft hailed the ruling as a victory, but said it would continue to push for a ballot measure that would allow it to continue classifying drivers as independent contractors. Lyft will suspend its ride-hailing operations in California at 11:59 p.m. Pacific Time on August 20th, the company confirmed in a blog post. Along with Uber, the company was ordered by a state judge to employ its drivers rather than classify them as independent contractors. But Lyft is choosing to end its service in California rather than comply with that order, at least for now. This is not something we wanted to do, as we know millions of Californians depend on Lyft for daily, essential trips, the company writes. We're personally reaching out to riders and drivers to share more about why this is happening, what you can do about it, and to provide some transportation alternatives. Uber has also said it will cease operations in California at the end of the day, though it has yet to officially confirm it. A spokesperson for the company declined to comment, but shared a link to a Medium article arguing that Uber has been an essential transportation service during the pandemic. Lyft's bike and scooter sharing services will still be operational in California, as will its car rental service and public transit navigation tool. More information about Lyft's services in individual cities can be found here. Uber and Lyft are under enormous pressure to fundamentally alter their business models in California, the state where both companies were founded and raised billions of dollars in venture capital. Uber and Lyft say drivers prefer the flexibility of working as freelancers, while labor unions and elected officials contend this deprives them of traditional benefits like health insurance and workers' compensation. In January, a new law went into effect called AB 5, which makes it more difficult for companies to use independent contractors. The law was mostly targeted at ride-sharing companies like Uber and Lyft, which have built their businesses on the concept of independent contractors shouldering the costs of their work. In May, California Attorney General Xavier Becerra, along with city attorneys of Los Angeles, San Francisco, and San Diego, sued the companies, arguing that their drivers were misclassified as independent contractors when they should be employees under AB 5. Becerra later filed a motion for a preliminary injunction that could compel the ride-hailing companies to classify drivers as employees immediately. California Superior Court Judge Ethan Schulman ruled in favor of Becerra, ordering the companies to immediately reclassify their drivers.